Good afternoon, everyone. Welcome to our webinar series on the U.S. Civics course, Government. We're looking at the government in the United States. The third section in that lesson, which is on the judiciary branch. My name is Paul. I am the social studies instructor here at Penn Foster High School. A couple of nice ways of being able to reach out to myself, the rest of the education department. Our phone number is 1-888-427-1000. There is an instructor line that will be able to get you directly to a member of the educational staff. And then whatever course you're concerned about, needing questions on, just let us know and we'll be more than happy to help you out. You can also reach us by email on the help and support page. There you're just able to type in a question. You'll be able to click on ask a question and then be able to compose that email regarding any concerns that you have. Please be aware that we also have both live help office hours as well as other webinars by our educational team. You should have message centers updates on all the webinars that are going on throughout the month of June. So take a look at the schedule. By all means, check on that schedule, see what works for you. Just like the webinars that I'm holding, they are all recorded and sent out to you afterwards. So as long as you register, you'll be able to get that material. A new outreach effort that we are developing and working on. It was sent out to you on the chat feature. It is a webinar. It is an appointment scheduler that you can actually set up an appointment with someone within our educational staff to be able to ask questions on the social studies courses. So if you have any concerns with your U.S. Civics course, later on with your American history or world geography courses, you can just use that link and be able to set up an appointment that myself or one of our teaching assistants would be able to reach out to you and be able to offer you any assistance that you need. There are other schedulers for our other courses. So if you do have anything that you want to go over with an instructor, use the phone, use the email to be able to ask for any help, or the live help or webinar schedules. You can be able to ask about those webinar schedules or those appointment schedulers, I should say, that again, you can set up a time that works for you, and then we're able to give you a call at that time to be able to answer any questions that you have. In terms of a couple of helpful hints I know are that help students be successful in their program, making sure that you are going over all the reading assignments within each lesson, taking notes based on the objectives, and also completing the practice exercises. Great ways to make sure that you are understanding what you're learning, understanding what you're reading. And then if you do have questions, that's a perfect reason to either go to a webinar, go to live help, email, phone calls, or again, using that appointment scheduler to be able to ask questions of myself, of the rest of our educational team. And please remember that your exams are multiple choice, are open book. So if you do, as you're going through the material, as you're working on the notes, when you get to the exam, if you need to go back and look at that material, by all means, definitely take a look and be able to get all the help that you need. For the webinar today, we'll be covering the forms of the federal court system, essentially the levels of the federal court system, as well as the practices and examples of our courts. And then a couple of the major Supreme Court cases that your reading assignments go over. We'll talk a little bit more closely about that. As I mentioned, you will receive a recording of this tomorrow afternoon. You'll get an email just like the registration email. When you get that email, you'll see the recording that you'll be able to just open up and be able to view. Any questions as we go along the webinar, please feel free to send them over. If I don't get to them during the course of my talk, I'll certainly be able to answer any questions at the end of the webinar as well. So first off, looking at our federal court system. And one of the big important aspects of our court system is just the way our judges are judges are set up, our justices. So they are appointed for life our courts and our founders really wanted to make sure that our federal court system and our judges were essentially above the political fray. That they don't have to worry about re-elections. They don't have to worry necessarily about making the most popular opinions. They're meant to interpret the law, interpret the Constitution, be loyal to the Constitution. They are appointed by the president. President Trump just had his first Supreme Court justice approved a little over a month ago. The president appointed him, and then our U.S. Senate then confirmed him by a majority opinion or majority vote, approving Neil Gorsuch as a new Supreme Court justice for the United States. Our lowest level of federal courts are called district courts. And within our court system, these are essentially the trials that go on that involve the Constitution. So every federal court case has to revolve around an issue within the Constitution. And the district courts hold the trials. They're the courts that you often see in terms with judges, with the lawyers presenting evidence, and then the jury making an opinion. And there are 94 district courts across the country, and each and every court and each and every district has to be within a state. So I picked the state of Texas, for instance, that has 4 district court groups, or districts, I should say, and they're all within the state, and they're based on population. So similarly to the representation within Congress, based on populations, there should be an equal number of citizens within each congressional district. Similarly, at the district court level, so within each of those 4 district courts are about the same number of people. And so they handle all the cases, the federal court cases that begin at that district level. The next level is our appeals courts, and they are based on the regions within the country. A map very similar to this is in your reading assignments, in which whole sections of the country are divided between these 11 appeals court sections or appeal courts groups. It's important to know that within the appeals court process, so if a district court decision, whoever loses that district court decision can appeal to the appellate court, to the regional appeals courts, and in those appeals, no new evidence is able to be entered. So the lawyers have to basically talk about the evidence that's already been discussed. Discuss what happened in the court, what happened with the jury, what happened with the judge, what happened with any rights of the defendant. And the appeals court judges will directly ask questions of the lawyers. Each side, the plaintiffs and the defendants, have an equal amount of time to present their case. And during that process, they are then asked questions. They can be asked questions of the members of the Court of Appeals. And the majority opinion is based on the majority of the judges' interpretation of the law and of the Constitution. So they'll make a decision on what the appeal was based on. Whatever part of the Constitution the plaintiffs were trying to argue that this was an issue within the Constitution that goes against what the district court said, for instance. And it's based on the appeals court and based on the majority's opinion on what the interpretation of the law and the interpretation of the Constitution. And that brings us to our first poll question. So if you've been in previous civics webinars, we've talked about the issue of the check and balance system. So essentially, each branch within our federal government is kept in balance, is checked by another one of our branches. And so which one of these is not an example of that check and balance system? That a president appoints any new federal judge, that a federal court can rule a law is unconstitutional or interpret the Constitution, or that the House of Representatives confirms judges within or confirms an appointed judge. Which one is not an example of the check and balance system? Give you guys about another 10 seconds. All right, so this was a tricky question. So it was actually the fact that the House does not confirm the members of the federal courts. It is the Senate that confirms them. That's one part of the check. The president appoints a federal judge, so that's another part of the check and balance system. And then the interpretation of the law, the interpretation of the Constitution. So the federal court is able to rule law either for or against the Constitution based on their interpretation of the courts. We'll talk a little bit more about that in a couple of minutes. So the highest level of our court system. So first we have the district court level. If one of the sides is not happy with the decision by the district courts, they're able to appeal it to the appeals court. If someone's not happy with the appeals court decision, they can then push it up to the Supreme Court. And the Supreme Court has 9 justices. One is called the Chief Justice. They're the person who is essentially in charge. And then the other 8 are called associate judges. They all are equal in terms of how much power they have within the courts. The Chief Justice is able to have a little bit more as far as administrative tasks, administrative duties, but all 9 justices have equal footing in terms of deciding cases and deciding which cases that they're going to listen to. Because there are only 9 justices, each level of all 11 appeals courts have between 9 and 11 justices, and district courts there are several in each of the 94 districts. So there are only 9 justices, and they all hear the same cases. So in each year, the judges can only listen to a few of the cases that come up to them. You know, there's always a side that's unhappy with what happens at the appeals court process. So many of them try to go to the Supreme Court, try to have their case listened to the Supreme Court, but in general, they're just not able to listen to all of them. And they decide on their cases first on any high significance of the country. So we've had cases involving civil rights. We had several cases that looked at President Obama's healthcare law based on the significance to the country, that the country needed to know what the Supreme Court believed on those cases and decide whether or not certain laws are constitutional. The Supreme Court also looks at what the appeals courts have already said. And they're more likely to hear a case if they have 2 or more appeals court deciding different things, if their interpretations of laws are different. So if the Ninth Circuit Court of Appeals out of the West decides a law is constitutional, but a district court in the southern United States, in like the 11th court, if they decide that a case or that a law is unconstitutional, the Supreme Court's more likely to take that law up because 2 different appeals courts that are equal have made different opinions, have decided on different opinions. The Supreme Court runs generally the same as the appeals courts, that each side will make their argument, will have an amount of time to be able to make their case, and each of the Supreme Court justices can ask questions. They can interrupt the lawyer anytime they want to be able to ask questions. Once the case is heard, it does take a while for the justices to make a decision, and they, just like the appeals court, have a majority opinion. And typically, the majority opinion is written by either the most senior member of the justices of the majority, or it's the Chief Justice. There was one famous Supreme Court justice, Chief Justice Earl Warren, or Warren Burger. I'm sorry, Justice Warren Burger, who was Chief Justice in the 70s and 80s. He would actually decide a case based on whether or not he was going to be in the majority. He would always want to be in the majority so he could write decisions. And the majority opinion is very important because that's the decision of the case. That's the decision by the court. So whoever writes the majority opinion is going to be the one who actually sets the law, sets up the case of this was either found constitutional or unconstitutional because of these reasons. Now, there can be concurring opinions. Other justices in the majority can write these concurring opinions that say, well, yes, I agree with the majority, but here are a couple of other points. These are other things that I either agree with or disagree with on the majority opinion. Typically, the majority opinion is one of the more centrist, is not going to be as far political as concurrent opinions. Concurrent opinions can generally be either very liberal or very conservative based on the justices. There are also dissenting opinions written by justices who are in the minority, who are obviously not the majority. So they're going to be the ones who say that the majority is wrong. And there have been many very famous dissents written in American history that have since become majority opinions. That some justices who wrote about segregation being unlawful back in the early 1900s, their dissenting opinions became part of majority opinions when civil rights acts were created and the Supreme Court acted against segregation in the 1950s and 1960s and 70s. So there's still a lot of importance in both those concurring and dissenting opinions as the Supreme Court evolves, as new justices come on to the Supreme Court, become members of the Supreme Court, and change their opinions. The majority can change between presidential terms. So for most of my lifetime, since the 1980s on, we've had a more conservative majority opinions. Republican presidents have appointed the majority of the Supreme Court nominees. In any given year, that can change based on retirements of Supreme Court justices as well as changes of presidents. We now have 5 more conservative justices and 4 more liberal, more democratic justices on the Supreme Court today. Our next poll question. Which of the 3 will not be a basis for who writes a court's majority opinion? Will it be the seniority of the members, the passion of a justice on a particular issue, or is it also the person being of Chief Justice, the position of Chief Justice? Which one is not a basis for choosing the majority opinion or writing the majority opinion? Another about 10 seconds. Okay, thank you. So the one that's not the basis is actually the passion of the justices. So even if someone who is very passionate about an issue or very really cares about that position, they may not necessarily get to write the majority opinion. They are likely the ones who are going to write very powerful either concurring opinions or dissenting opinions. But they are typically not the ones who are going to necessarily write the majority opinion. Sometimes they do because they are either the most senior member of the majority or they are the Chief Justice. But in many cases, they are the ones who give really powerful, again, concurring or dissenting opinions. There was someone who had a question. I'm unfortunately not sure who that was. But if you do have questions, you can certainly type them in. The last thing that we'll talk about today are the powers and practices of the Supreme Court. So the main job of the court, of federal courts, is to interpret the Constitution. That is written within the U.S. Constitution. And for the beginning of American history, there wasn't a clear understanding of what interpreting the Constitution meant. What exactly became, what is the job of the judiciary, of the federal branch. And by the early 1800s, the courts essentially create their own rule, create their own decision, and that is they have the process of what's called judicial review. And in the process of judicial review, the Supreme Court and the federal courts can essentially say, based on their review, based on evidence, based on interpretation, based on what they see as what's necessary within the Constitution, what's necessary within federal law, they can decide if a law passed by Congress, signed by the president, they can decide if that law is constitutional, if it follows the Constitution. We are currently seeing that kind of play out with the travel ban that President Trump signed as an executive order when he first became president. Several of our appeal courts have already said that is not constitutional, that the travel ban is not constitutional because it limits people's freedoms. It limits that the federal law does not allow, and the Constitution does not allow for the president, Congress, for anyone to discriminate against religion or against race. And by several appeals courts, they have argued that the travel ban is again unconstitutional because of those reasons, as discrimination against both religion and ethnic group or by country of origin. A couple of other famous court cases. The first one was Miranda versus Arizona. You may have heard the term Miranda in law movies, in TV shows that go about the law. The case itself essentially came down to what are the rights of the accused, and most of the rights of the accused come in the Fifth Amendment of the Constitution. And this Supreme Court case overturned a number of procedures at the local level, at the state level. And it began to require that anyone being arrested must be what's called read their rights. And the Miranda rights are actually written into your reading assignments and your digital study guides. And essentially goes that you have the right to remain silent. Anything you say can be used against you in a court of law. You have the right of an attorney, present now and during any future questioning. If you cannot afford an attorney, one will be appointed to you free of charge if you wish. So these Miranda rights, as they're now called, spell out simply what's required within the Fifth Amendment. That accused people do not have to necessarily incriminate themselves, do not have to answer questions. That they have a right to be to have an attorney. They have a right to representation. These are written in the Fifth Amendment, and now part of the Supreme Court code within this Miranda versus Arizona Supreme Court case. So the Supreme Court was able to look at these laws at the state and the local level that really limited the Fifth Amendment, limited the rights of the accused, and the court majority basically said, no, these statements must be said to each and every accused person as they're being arrested. People have to know their rights right away before anything else can happen. The second generally very controversial court case was one of Roe versus Wade. This is the right of that abortion rights became pretty well known. And the Supreme Court essentially decided that there is the right of abortion is based on privacy and based on personal autonomy. That federal court, the federal law and state law and even local law cannot infringe on privacy and personal autonomy of people. This did allow for abortion to become legalized in the United States, and ever since then it's become a political argument that we have a pro-life and pro-choice movements in this country based on this 1973 Supreme Court case. A number of other cases have come up on the issues of abortion that have not outright changed Roe v. Wade, have not overturned Roe v. Wade, but the Supreme Court has, since this case, allowed for different limits on people's on the rights of abortion, and put more and more authority at the state level to be able to set laws, set restrictions on the health care for abortions. So this comes to the end of my presentation. Are there any questions?